We have some breaking news here. I have published my most recent law review article, my piece of scholarship, on the Second Amendment in the Harvard Journal of Law and Public Policy, a very influential journal. I'll put a link to it down below. You should check it out. The title of the article, or the essence of the article, is how the U.S. Supreme Court's decision in Rahimi is going to allow us to knock out more and more gun control laws, and how everything that milquetoast moderate, that's a joke, right? Milquetoast moderate Merrick Garland, the most moderate man ever nominated to this U.S. Supreme Court, supposedly, failed utterly in his attempt to knock out the Bruen methodology in Rahimi. This article lays it out in extreme detail in a scholarly way that you can use in your court cases, that you can use in your scholarship, that you can use in your op-eds and in your discussions in social media. Let's talk all about this new article by Mark Smith in the Harvard Journal of Law and Public Policy about the Second Amendment when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Terrorist Attacks Teach Americans About the Right to Bear Arms. We must always learn the lessons from mistakes others have made in failing to protect the private right to self-defense and the private right to arms. Mistakes Israel made, we do not want to make those same mistakes here in the United States. Check out Israel Disarmed on Amazon. All right, folks, so I think this is important news. I have just published my most recent article in the Harvard Journal of Law and Public Policy. I will put a link to it down below. You may want to check it out. It's not that long. It's about 4,000 words or something like that. So it's pretty easily digestible. I try to write it in a clear kind of way. Obviously, it's a little academic and very scholarly in one sense, but I try to write it quite clearly. The title of the article is Much Ado About Nothing. Rahimi reinforces Bruen and Heller. That's right. The whole point of the article is to dispel these gun controller myths that somehow the Supreme Court's Rahimi decision, which I've been predicting, you knew I predicted it, you all predicted it, we all knew it was going to happen. The Supreme Court was not going to let Mr. Rahimi, with his terribly violent past, including in being involved with 5 shootings and everything else, they were not going to allow him to have a gun under the circumstances. He was going to be disarmed during the pendency of that domestic violence restraining order, given the fact of his violence and the fact that he's in prison and so on and so on. And the way the Supreme Court did it made a lot of sense, and it is not going to have a negative ripple effect against the Second Amendment, nor is it going to benefit the gun controllers. It is absurd. Now, the anti-gunners are trying to pretend that somehow this Rahimi decision is a big win for them. That is utter nonsense. As we just saw a week or so ago in the United States Court of Appeals for the 8th Circuit, out of Minnesota and the like, Minnesota, Missouri, and the like. I apologize for that. The 8th Circuit said, using Rahimi, that 18 to 20-year-olds have the right to keep and bear arms, no different than anybody else, and they relied on Rahimi to come up with that favorable Second Amendment decision. So we're going to see more and more of that in the future. And again, in my article in the Harvard Journal of Law and Public Policy, I discuss this in great detail. And let me just give you the highlights of the article, and then you can read it down below if you want. The first is, I really hammer home that the Rahimi decision reiterated and relied upon the Heller-Bruen framework. This is extremely good for us, because where the anti-gun movement wants to go is they want to balance away, using interest balancing or tiers of scrutiny, they want to balance away our Second Amendment rights by arguing that the gun control is motivated by good public policy concerns and public safety concerns, and we should always be balancing the good of guns against the bad of guns. That is utter nonsense, because as Justice Scalia wrote about in Heller, the balancing of the good and the bad of guns was already done by our founding fathers, and it found its way into the Second Amendment. Just like the good and the bad of free speech was balanced away in a sense and finds its way into the text of the First Amendment. So the balancing of our rights has already been done by the Founding Fathers. It found its way into the text of the Constitution, including the text of the Second Amendment. So again, the anti-gunners wanted to destroy the Heller-Bruen methodology, which, as you know, is you read the text as understood, what the text was understood in 1791 when it was written. And then if a modern-day gun control law implicates that text, the burden shifts to the government to show that there is a long-standing historical tradition of some sort of firearms regulation that would allow the modern-day gun control law to stand. The example I like to give is there has always been laws against using guns and other weapons to commit murder, so the right to keep and bear arms in the text of the Second Amendment would obviously not give rise to your ability to commit cold-blooded murder. And in the case of Mr. Rahimi, so too there was a sufficient number of long-standing historical traditions of disarming violent people, both in the civil context, known as what are called the surety laws, which I discuss in this article, as well as in the criminal context, what are known as going armed laws, or using firearms or other weapons to the terror of the people. This was a basis for the Supreme Court to say that there's long-standing laws that were literally discussed by some of the most important influential commentators in English law, for example, William Blackstone. And this is a critical point I make in this article in the Harvard Journal of Law and Public Policy. I emphasize that one of the critical things the Supreme Court did is they found laws that were really ensconced, embedded in culture, both in England and the United States, so much so that they found their way into Blackstone's commentaries. That's how well established these historical traditions of firearms regulations were, and that is going to be a huge hurdle for the anti-gunners to overcome in other Second Amendment fights, like we saw again a week or so ago in the Eighth Circuit's case in Worth, where they relied upon Rahimi to knock out the Minnesota gun restriction law dealing with 18 to 20-year-olds and their ability to carry. That law prevented them from carrying guns in public, getting the CCW license because they were too young. That is no longer the case because the U.S. Court of Appeals, relying on the Rahimi decision, knocked out that law. The other critical thing, of course, I talk about in this article is how important it was that the text of the Second Amendment was utterly respected, and that despite the fact that Mr. Rahimi clearly was not a good guy and engaged in all sorts of violence, he was still textually part of the people. Remember, the text of the Second Amendment reads, the right of the people to keep and bear arms shall not be infringed. Now, one of the things the anti-gunners are desperate to do is to try to get anyone and everyone in the United States to be excluded from the textual definition of the people. Why? Because as we've talked about, once you're part of the people and there's a modern gun control law that restricts your ability to keep or to bear arms, the burden shifts to the government. And the government hates the fact that the burden shifts to them to show a historical regulation of some sort, of historical regulations and so on and so on. So therefore, they really want to win all their fights over the Second Amendment at the textual level before the burden shifts to the government, because once the burden shifts to the government, it makes it very difficult for them to justify modern-day gun control laws. And I point out that despite the fact that Mr. Rahimi was really violently a terrible person based on this record, right, and all the things that went on, and being involved with 5 shootings, shooting at witnesses, taking his girlfriend's head and hit it in the dashboard, when someone saw it, he shot at the witness to try to kill the witness who could not report, on and on and on and on. And of course, he admitted he did all this stuff and admitted and agreed to the consent that he was a violent danger to his ex-girlfriend and so on. So, this is a terrible case, which is exactly why milquetoast moderate Merrick Garland, and I call him milquetoast moderate Merrick Garland because that's how he was described when he was nominated to fill the empty seat of Justice Scalia. So that's why I make fun of the fact he obviously is a radical, anti-gun, anti-American Attorney General, but he was sold by Barack Obama and others as a milquetoast moderate, ordinary rule of law guy when they nominated him for the Supreme Court to replace Scalia when Scalia died. Thank God, because of Mitch McConnell and Senator Chuck Grassley, he never got a hearing, and ultimately Neil Gorsuch, who's been very good on the Second Amendment, got that seat of Justice Scalia's and not milquetoast moderate Merrick Garland. So again, this is really important because they made it clear that Mr. Rahimi, despite his record, was part of the people, so there was no dispute, which meant the entire Rahimi decision was focused on, did the government come forth with powerful enough, compelling enough historical traditions to show that he could be disarmed on this record? And the court said that the law, 18 U.S.C. 922 G1, facially could not be knocked out because it was legally applicable and legally constitutional as applied to Mr. Rahimi. Now, that's not going to get the anti-gunners very far when they start litigating cases where people have no violent background and have never, and if they have a violent background, it's far in the past, they're going to have a very difficult time satisfying that in the non-violent felon context, which the anti-gunners really need to win, because the truth is most people that are truly violent gangbanger terrorist types are likely going to be in prison for decades and decades and decades, and that is not sort of a natural constituency of the Second Amendment movement. So again, with that said, there's obviously the opportunity for restoration, but that's a whole separate issue that we're not litigating or fighting about right this second. Now, the next thing I talk about in the Harvard Journal of Law and Public Policy, again, the link to the article is down below. Feel free to read it and comment. Tell me if you disagree with it or if you like what I said. I talk in extreme detail about just how robust the historical tradition was, because again, in these other Second Amendment cases dealing with sensitive places, dealing with 18 to 20-year-olds, dealing with nonviolent felons, dealing with quote-unquote assault weapons, which has already been established by the Heller and common use test, the point is that the nature of the historical tradition that had to be satisfied here was extremely high. Because if you're talking about historical traditions that are so robust, they found their way into the most important commentaries of the time of the founding. William Blackstone was a huge deal. He was an English lawyer who wrote something called Blackstone's Commentaries that summarized the most important aspects of English law. And the laws that the Supreme Court in Rahimi relied upon to justify disarming Mr. Rahimi temporarily because of his violent background were so long-standing and well-established that they were laws that were discussed extensively in Blackstone's commentaries. So this is going to be very difficult for the anti-gunners to satisfy when they come forth with like, hey, there's like 3 laws in Tombstone, or there's like 4 laws in Massachusetts for 5 years, or in 1650 the Virginia Commonwealth had like 3 laws. No, it's not going to be good enough, because again, the standard set for what is a historical tradition is really robust. Because if these laws that the government is using to try to take away our gun rights and to restrict the definition of the Second Amendment, if these laws are trying to use were not so well established as they find their way into, let's say, Blackstone's commentaries and Hawkins, things like this, they're going to lose. That is very good news, and I point this out in this article right here. So I just want to read you one part here just to show you how I really go after this anti-gun propaganda among these elite intellectuals with their fancy credentials. Luckily, you know some of the very fancy credentials too. So guess what? Here's what one guy with very fancy credentials and real authentic, beautiful, luxurious hair has to say about those anti-gun scholars and their spin to try to take out the Rahimi argument, the argument that Rahimi somehow destroys the Heller-Bruen methodology. It does nothing of the kind. It reaffirms it. Here's what I write. All members of the Rahimi court, even those who would have decided Bruen differently, believe themselves to be faithfully applying Bruen. It is therefore a threshold mistake to pit Rahimi against Bruen instead of focusing on the vast common ground between the majority and the dissent in Rahimi. All justices, that's all 9 justices, agreed on the absence of any dispute about Mr. Rahimi's conduct falling well within the textual protection of the Second Amendment, the high historical provenance and pedigree of laws required to constitute a tradition, the tight logical nexus required between the historical laws and the identified tradition connecting them, and the irrelevance of interest balancing and so-called experts to the determination of whether a modern regulation transgresses the Second Amendment as a matter of law after Bruen. That's powerful language from a handsome YouTuber, but check it out, because this article makes the case, and don't go down bad paths in attacking the Rahimi decision. There is a intramural fight about one aspect of the why and the how between Justice Thomas on the one hand and the other 8 justices, but I view that to be an extremely narrow intramural dispute. And I think ultimately what I point out in this article is what makes the Rahimi case so important and so precedential in a sense is this, that up until this every Supreme Court case in the modern era dealing with the Second Amendment was groundbreaking in one sense. Heller said that you had an individual right to keep and bear arms. McDonald says that that individual right to keep and bear arms was so fundamental that it applied against the states and localities in 2010. Then we go on and have, of course, the Bruen decision, which reaffirms Heller and says that indeed there is no interest balancing. It's all about the text, what the text was meant to at the time of the founding. The burden shifts to the government, and the government bears the burden to show this that there's some sort of historical tradition of firearms regulation in order to justify it. All of this was building a gestalt or a framework, and why Rahimi is so important is at the end of the day, it's really a very pedestrian case of trying to figure out where the line is in a particular dispute, which the Supreme Court does every single term involving the First Amendment, the Fourth Amendment, the Fifth Amendment, all aspects of the Bill of Rights, and of course the Constitution. And the fact is that the Rahimi case was sort of a pedestrian case and not a groundbreaking case in and of itself is very significant because it shows that the Second Amendment is now moving from groundbreaking jurisprudence into normal constitutional jurisprudence and litigation where it's all about line drawing. That's not to say there's not big cases coming down the pike. There certainly are, and we're going to get those as we get final judgments in the lower courts. The court will start to take those cases on final judgment soon enough, and maybe even as soon as this term, we'll see how it plays out in the inferior courts. But anyway, there you have it. So I will put a link to my article, Much Ado About Nothing, talking about how Rahimi reaffirms Bruen and Heller and why it's so good for the Second Amendment movement. Check it out. And again, I got an even bigger article coming out in about a month or so, but that'll be a topic for a different discussion, and you'll be very happy with that one as well. All right, folks, hope you learned something here today. Make sure you subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.